On October 30th, a Washington, D.C. federal court granted an injunction against the enforcement of Trump's ban on trans people in the military. In the court's judgment, the plaintiffs litigating against the ban stand a very good chance of successfully arguing that it violates their Fifth Amendment rights. Judge Colleen Collar-Cotley wrote, "The court holds that plaintiffs are likely to succeed on their Fifth Amendment claim. As a form of government action that classifies people based on their gender identity and disfavors a class of historically persecuted and politically powerless individuals, the president's directives are subject to a fairly searching form of scrutiny. Plaintiffs claim that the president's directives cannot survive such scrutiny because they are not genuinely based on legitimate concerns regarding military effectiveness or budget constraints, but are instead driven by a desire to express disapproval of transgender people generally. The court finds that a number of factors, including the sheer breadth of the exclusion ordered by the directives, the unusual circumstances surrounding the president's announcement of them, the fact that the reasons given for them did not appear to be supported by any facts, and the recent rejection of those reasons by the military itself, strongly suggest that the plaintiff's Fifth Amendment claim is meritorious. Defendants, the Trump administration, shall be preliminarily enjoined from enforcing the accession and retention directives, the directives banning recruitment and retention of trans people, corresponding with sections 1B and 2A of the presidential memorandum, until further order of the court or until this case is resolved. Plaintiffs have also challenged the presidential memorandum's prohibition against the expenditure of military resources on sex reassignment surgeries. Because no plaintiff has established a likelihood of being impacted by that prohibition, the court lacks jurisdiction to adjudicate the propriety of this directive. This is the part over which the court agreed it had no jurisdiction. The plaintiffs were not seeking surgery, so they couldn't litigate against the military's policy against it. Before the military decided to allow trans people to serve openly, they did extensive research into the effects it could have. The working group, a research group designated by the military, sought to identify any possible issues related to open military service of transgender individuals. It considered a broad range of information provided by senior military personnel, various types of experts, health insurance companies, civilian employers, transgender service members themselves, and representatives from the militaries of other nations who allow open service by transgender people. Finally, the working group commissioned the RAND Corporation's National Defense Research Institute to conduct a study on the impact of permitting transgender service members to serve openly. The RAND Corporation subsequently issued a 91-page report entitled Assessing the Implications of Allowing Transgender Personnel to Serve Openly. The RAND report found no evidence that allowing transgender individuals to serve would have any effect on unit cohesion, and concluded that any related costs or impacts on readiness would be exceedingly small, marginal, or negligible. The RAND report also found that in no case where foreign militaries have allowed transgender individuals to serve was there any evidence of an effect on the operational effectiveness, operational readiness, or cohesion of the force. There is no evidence that allowing trans people to serve is in any way detrimental to the efficacy of the foreign militaries that currently permit it. The U.S. military is of course very different from other militaries, but it has shown no evidence that its differences would leave it vulnerable in a way that other militaries are not if it were to allow trans people to openly serve. Since the president's directives are subject to a fairly searching form of scrutiny, this judge argues, the burden of proof is on the Trump administration to justify the ban. This is due in no small part to the fact that the U.S. military has not merely failed to provide evidence of potential harm, but has in fact provided evidence to the contrary. Based on all of the information it collected, the working group unanimously concluded that transgender people should be allowed to serve openly in the military. Not only did the group conclude that allowing transgender people to serve would not significantly affect military readiness or costs, it found that prohibiting trans people from serving undermines military effectiveness and readiness, because it excludes qualified individuals on a basis that has no relevance to one's fitness to serve, and creates unexpected vacancies requiring expensive and time-consuming recruitment and training of replacements. So not only is there no evidence that trans people harm the military, there is evidence that banning them would. Plaintiffs asked the court to enjoin the enforcement of the accession and retention directives pending the final resolution of this lawsuit. The court will grant plaintiffs' motion. The court finds, 1, that plaintiffs have a likelihood of succeeding on their claim that the accession and retention directives violate the Fifth Amendment. 2, that plaintiffs would suffer irreparable injury in the absence of an injunction. And 3, that the balance of equities and the public interest favor granting injunctive relief. The ban on trans people in the military, being discriminatory, could violate the Fifth Amendment. The general rule is that government action that treats certain classes of people differently is presumed to be valid and will be sustained if the classification drawn is rationally related to a legitimate state interest. However, this general rule does not apply where the government action draws distinctions between individuals based on certain suspect or quasi-suspect classifications. In those instances, the court must apply a heightened degree of scrutiny. On the current record, transgender individuals who are alone targeted for exclusion by the accession and retention directives appear to satisfy the criteria of at least a quasi-suspect classification. Trans folks are frequently subjected to unwarranted discrimination, so any policy that discriminates against them is properly properly subjected to heightened scrutiny. The court pauses to note that meaningful scrutiny of the constitutionality of the accession and retention directives is appropriate despite the fact that they pertain to decisions about military personnel. Although the court recognizes that deference to the executive and Congress is warranted in the military context, the court is not powerless to assess whether the constitutional rights of America's service members have been violated. While the military has higher standards when it comes to whom they employ, and deference is sometimes granted to the military to make personnel decisions, even rationally discriminatory ones, the military does not have carte blanche to discriminate however they see fit without ever providing justification. Defendants argue that this policy is necessary for three reasons. First, defendants argue that at least some transgender individuals suffer from medical conditions that could impede the performance of their duties. Second, defendants argue that there is room for the military to think that certain medical conditions may limit the deployability of transgender individuals as well as impose additional costs on the armed forces. Third, defendants argue that the president could reasonably conclude that the presence of transgender individuals in the military would harm unit cohesion. And there's a footnote that says, plaintiffs note that similar arguments were proffered in support of prior policies precluding service members from being openly gay, maintaining racially segregated ranks, and excluding women from military colleges. Plaintiffs do not dispute that maximizing military effectiveness, lethality, and unit cohesion, and even budgetary considerations are all important or at least legitimate government interests. They do challenge, however, whether defendants can satisfy their burden of demonstrating that the discriminatory means that have been employed in the presidential memorandum, the accession and retention directives, are substantially related to the achievement of these objectives. Based on the combined effect of a number of unusual factors, the court finds it likely that plaintiffs will succeed on this claim. First, the reasons given for the decision to exclude transgender service members appear to be hypothetical and extremely overbroad. For instance, defendants cite concerns that some transgender individuals could suffer from medical conditions that impede their duties, and assert that there is room for the military to think that transgender people may be limited in their deployability at times. As an initial matter, these hypothetical concerns could be raised about any service members. Moreover, these concerns do not explain the need to discharge and deny accession to all transgender people who meet the relevant physical, mental, and medical standards for service. The accession and retention directives are accordingly extremely overbroad when considered in the light of their proffered justifications. Even if it is the case that trans folks are more likely to have certain medical conditions than the general population, this does not justify a ban on all trans people. It does not justify terminating the employment of personnel who have served for decades in some cases and never had any detrimental medical issues. It is not a reason to ban trans soldiers who have demonstrated that they are healthy. The breadth of the accession and retention directives is also discontinuous with the purported concern about costs, which, in addition to having been found to be minimal or negligible, apparently are primarily related to a surgical procedure that only a subset of transgender individuals will even need. Similarly, defendants provide practically no explanation at all, let alone support, for their suggestion that the presence of transgender individuals may be harmful to unit cohesion. Indeed, defendants themselves highlight the absence of any prior studies or evaluations supporting the proffered justifications by arguing that they must now conduct studies regarding transgender military service before they can adequately defend the president's decision. At most, defendants' reasons appear therefore to be based on unsupported, overbroad generalizations about the different talents, capacities, or preferences of transgender people. Nonetheless, given the deference owed to military personnel decisions, the court has not based its conclusions solely on the speculative and overbroad nature of the president's reasons. A second point is also crucial. As far as the court is aware at this preliminary stage, all of the reasons proffered by the president for excluding transgender individuals from the military in this case were not merely unsupported, but were actually contradicted by the studies, conclusions, and judgment of the military itself. As described above, the effect of transgender individuals serving in the military had been studied by the military immediately prior to the issuance of the presidential memorandum. In connection with the working group chaired under the Secretary of Defense for Personnel and Readiness, the RAND National Defense Research Institute conducted a study and issued a report largely debunking any potential concerns about unit cohesion, military readiness, deployability, or healthcare costs related to transgender military service. The Department of Defense Working Group, made up of senior uniformed officers and senior civilian officers from each military department, unanimously concluded that there were no barriers that should prevent transgender individuals from serving in the military, rejecting the very concerns supposedly underlying the accession and retention directives. In fact, the working group concluded that prohibiting transgender service members would undermine military effectiveness and readiness. In short, the military concerns purportedly underlying the president's decision had been studied and rejected by the military itself. If the Trump administration wants to do their own study, maybe it will produce different findings. But until they do, the judge argues, the ban on trans soldiers lacks constitutionally required justification. Defendants cite a number of cases for the proposition that the presidential memorandum is subject to a highly deferential form of review. The court has reviewed those cases and determined that none of them require the court to apply a different level of scrutiny than has been applied here. While deference may often be granted to the military, such deference is not applicable when it comes to certain forms of discrimination. Judge Collar-Codley has decided that if the military wants to discriminate based on gender identity, the burden of proof falls on the military to justify that discrimination. If there are sufficient reasons to keep trans people out of the military has to give evidence for them. The court has decided that speculations about what the effect of trans soldiers hypothetically could be are not sufficient. Thanks again for helping me out on Patreon.